what protects the parties that come before the court from seeing the court just do any old thing it likes to those parties? And that guarantee that the court can't just do any old thing it likes to the parties before it is that, don't worry, we can't just do anything we like, because anything we do, we have to follow that in the future. So don't worry, we're not going to do anything crazy to you, because then we'd be obliged to do that same crazy thing in the future. But the unpublished opinion rule takes us out of that guarantee. And so the parties no longer have the guarantee that you're not going to do some crazy thing to me, because that would be binding on you in the future. Because when it unpublishes a decision, it says, no, whatever we did to you is just buried in the record. You can't gainsay it. No other, it's not reviewable. It's not citable by any other court. We don't have to follow it in the future. So it's kind of all bets are off.
Well, you're trotting in the steps of the, I suspect he's now dead, the late great Gideon Canner, who was a professor of law at Loyola, who loved to write articles for the Daily Journal, the gravamen of which was, I've had these appellate opinions that disagree with each other, and I can't even tell the court that it's disagreeing with itself. Your real point is that the Court of Appeal is too often, particularly in what we'll call the boring cases, where there's not a sexy constitutional issue that will get taken up, the very last court. Now, can you figure a way to solve that problem? And I'm not sure that the publication, now what you're saying is we published everything, that would keep the courts of appeal honest. The Court of Appeal is producing, all courts of appeal everywhere are producing way too many opinions. And the possibilities of trying to reconcile. I mean, can you imagine even a simple contract case where able counsel is able to cite 100 contract, what otherwise would have been 100 contract cases out of this Court of Appeal that supposedly go in the opposite direction. And then you've got the task of distinguishing those 100 cases and explaining, no, these have been misapplied, goodbye, we see through your argument. It would only gratuitously increase the workload of the intermediate courts. Sorry.
But from the standpoint of the parties would say, that sounds like a you problem. That's not a me problem. I'm entitled. If I wanted to go to private judging and just go to jams and have an arbitrator just do any old thing to me, I could always do that. But I elected to go through the court system, through the justice system, because we have these rules, and the judicial power is of such a nature that it is constrained and obliged to give me a reasoned opinion that is binding in future cases. And that's the essence of judicial power. And just because it's inconvenient or cumbersome to do that, I think from the standpoint of the parties, that's not my problem.
Tim, there are 120 plus appellate judges in the state of California, more than 1,000 Superior Court judges. There is and those 120 appellate judges produce at least 100 opinions to maybe 150 opinions a year. If they were all publishable and citable as precedent, it would be too cumbersome. I'm sorry, yes, it might be a you problem versus a me problem, but I think unless you are prepared to have essentially a court of appeal look, a different court of appeal over every superior court division in the state of California. And by the way, that would be bad too, because I have to mention one more thing that you haven't mentioned. In California, unlike the Ninth Circuit, we don't have horizontal stare decisis. We have, it's only vertical.
Right.
And that means that one panel can disagree with each other.
Right. The respective district courts of appeal opinions are not binding on each other.
But you mean at the federal level?
No. At the court level, at the California Court of Appeal level.
Yes. Yeah. In fact,
unlike in the Ninth Circuit, where anything they do is binding on themselves.
Supposedly binding, and more they are finding it difficult to reconcile some dumb opinion that was written 10 years ago with the dumb opinion they want to write today. Yeah, I get it.
Yeah.
So I unless you have a solution, a practical solution, other than a society devoted to total law, I don't know what.
What about the federal rule where they have unpublished opinions, and they are citable for persuasive value only? What about a system like that, amending Rule 8.1115 and the California Rules of Court to allow litigants to cite, but they're only persuasive?
Tim, if we really did have, that's the functional equivalent of just publishing everything. Because if it's citable for persuasive value, you can start larding your briefs with just any number of cases. Now, maybe we should rethink the horizontal stare decisis. Maybe we should, go to some sort of stare decisis within a given district or within a given panel. Maybe that would change the jurisprudence and at least bring given panels and given districts into consistent. But then you've got one problem. I'll just raise it. I encountered it in my career at some point early in my career, which is the judge who has an agenda and wants to write on some hot issue first, writes first, and that's the problem with horizontal stare decisis. In other words, I like my name in print. I'm going to write on this now. And then all of a sudden, that didn't make sense in the second case. Now, so at least when we don't have horizontal decisis, the second panel can say, our colleagues down the hall perhaps misjudged or misfigured the full force of the statutory language.